So typically we will include all of the employee defendants under any sort of settlement agreement we reach at mediation.
Right, but when you actually go to the mediation,
Um,
how does that work when you have incidental parties maybe, or, or have you done those? It's usually you that appears?
yeah, to date, we've always had, if it's individual named employees, we are representing them as well. So it's just us. This is at least the first one since I've been working with the city that we've had outside counsel.
Okay. Miss Arditi, and I do, from your own experience, the city is trying to mediate on behalf of their employees as well. Okay.
Correct. But
and
I will talk to Miss Rodriguez. I didn't mean to interrupt you, Judge. I will call Miss Rodriguez later because I did discuss a little bit with Steve Blanco. So,
right. And sometimes you may have to tell them what I'm trying to convey to Ms. Hanson, that yes, she unleashed the whole machine of a lawsuit, which is she's entitled to do. I guess she filed she sued your client personally.
Correct, Judge.
Okay. And again, Ms. Hanson, there are no rules, Ms. Hanson. You could do that. I'm just saying normally that hasn't been done. It isn't done because the city, but there are tactical reasons to do it. Okay. So maybe you had a tactical reason for doing it or not. So Ms. Arditi, if you insist on being at the mediation,
I would, Judge. Yes.
Well, I know you do, but I'm saying if you do that after you talk to your client, then I'll have a hearing to order that. I just didn't want to get this more complicated than it needed to be. But Ms. Rodriguez, if anybody wants to send their lawyer, they can send them. I don't know what that's going to do to you, but the lawyer can be there, and I don't know to what degree the law, because the mediation is between the plaintiff and the city, and you have even if you have other policies in place or procedures in place to try and settle everybody else out, another person, like another lawyer, can throw a monkey wrench, just say no, so I didn't want to complicate it like that, Ms. Arditi. Can you talk to your client and see if they insist that I order that they allow you to be there?
I will speak to my client,
and of course, if you recommend that,
and I will
Ms. Rodriguez first.
I will speak to Ms. Rodriguez first because I think that there's some issues that I've spoken to Steve. I don't know if she was privy to all of them, but Judge, before you issue the order, I would ask the court to wait till after I speak to Ms. Rodriguez, and that way you can just issue one order.
I'm not issuing an order. I'm doing an oral order.
Okay.
Everybody go to schedule mediation in the next 60 days.
Okay, Judge.
And then after that, and then of course I'm always available if you need to appear, and we can discuss any modifications I need to make to that. But do it within 60 days. Do it with Judge Ancliffe, and then after that, Judge Ancliffe will send me a report. You can ask him for a copy so that you can send it to me to make sure I got it. If you feel more comfortable, that just tell Judge Ancliffe the judge asked us to get a copy of your report to him. Send it to my court coordinator, and I'll have eyes on it as soon as we receive it. And then you can schedule after 30 days whatever relief you need based on whatever status of Ms. Hanson's performance in the discovery is. Okay? Ms. Arditi, I think we're fine then, because you're going to talk, Judge. And, you can have a hearing, and you can always schedule one of those.
Perfect. Thank you, Judge. And I will speak with Ms. Rodriguez, and if there's anything that comes up, we'll let the court know.
Okay. The second thing that I wanted to do, and I appreciate everybody's patience, but this is addressed to everybody. Next year is going to be my last year on this bench because I'm retiring after that. However, I am running for County Court at Law number 4. So I'm telling you that because I've told most of the panels that if you have any cases pending in my court, that sometimes they haven't been tried. A lot of times it's because if you're in the same trial docket as prisoners are, they take precedence. But also a lot of these civil cases work themselves out because the rules are designed for that. However, if anybody wants me to try a case that you have pending on the jury docket, please come in to see me or convey that to me, and I can make note of that. It's a lot easier for me to get a civil case jury because I can just schedule it and do it. When I do a criminal case, since I do felonies, I normally have to line up 2 juries, one for 200 people, because not everybody's going to show up, and it might be a child sex case, for example, and then one behind it for 100 people that I order for civil cases. But at least I have that second jury available if you can't see the jury on the first one. So it's way different from doing a civil case. So it's not a problem for me to try civil cases, even if I did one that was 3 weeks long one time. So that's what I'm here for. Just come to me and let me know. The judicial ethics allow me to ex parte on scheduling matters. So if you just want to drop by and say, Judge, I'd like a jury trial, I'd probably tell you, okay, let me look at your case, go let the other side know, and we'll have a hearing, a status hearing right before that, just to, try and figure all that out. Right? So thank you very much. And then Ms. Hanson, just be on the lookout, but they do need your address. And so Ms. Rodriguez, if she calls you, you need to get a hold of her to give her your address, okay? And then Ms. Rodriguez will give it to all the parties. And we'll send it out to all the parties. Your mailing address. Miss Hanson, you need to answer because, I did have a call. Okay, thank you.
I have her email. I can email it to her.
All right. Okay, and then would you make sure, Ms. Rodriguez, that you forward the email to the other lawyers if she didn't get it out to everybody?
Yes, Your Honor, I will make sure.
All right, thank you all. Have a good day.
Thank you, Judge.
Yes, ma'am. Bye. All right. Let's see who's next on the docket.
Hi, Judge.
Bye. Take care.
You too.
I have Jose Luis Tagle, a default hearing. Nobody here on that? Okay. Robert, would you let Ms. Jowdy know that we called her case and nobody was here? Is Kirsten D. Anastasia here for that case? All right. Next case is Nation Star Mortgage, a foreclosure against Yvette Beltran and Miguel Beltran. Is there anybody here on that case?
Yes, Your Honor. Bradley Conway here on behalf of Nation Star Mortgage.
Okay. 972, remind me what zip area code that is?
It's we're in north of Dallas, basically.
Oh, okay, Dallas. All right. I used to know all of them because I did it 35, 40 years ago when I graduated from law school. I was doing collections work, so I was familiar with all the area codes, but I think they've doubled the number.
Oh, yeah, definitely.
All right, so you have a foreclosure, and is Yvette Beltran and Miguel Beltran here or anybody here for that? All right, so tell me what you got and what you need, what you are asking me to do, sir.
Yes, Your Honor. This is an application for an expedited foreclosure under Rule 736. We've met all the requirements of Rule 736. The parties have been served at their last known address by the clerk. sending them by certified mail, and we're asking for an entry of a default order today against them, allowing
Okay.
foreclosure.
All right. So let me let me know a little bit about the ballpark figure of the amount, the value of the property in controversy.
Let me see. It is. It's a because we're doing a 736. This is a home equity loan. The the current amount to cure the default on the home equity loan is $49,715.29.
Okay, and so therefore the people that were that borrowed the money, they are now deceased. Is that correct?
I don't believe so. I don't have any indication that they're deceased. I just haven't received any sort of response from them on any of this.
Well, when somebody it's not a special home equity loan. It's just a conventional home equity loan by a lender and a borrower.
That is correct, yes.
All right. And when's the last time they paid?
The last payment was on, let's see. It would be May of 2024.
Okay. And do you have good reason to believe that one or both of the parties are still there at that home, or?
Um, I believe so. That's the last address we have for them. So nobody's changed their address. Nobody has sent us any information that they are somewhere else.
Okay, Mr. Conway, I'm just trying to figure out a couple of things. Okay, I guess
Sure.
if I tell you what my concern is, then
Of course.
um, if the parties are still there, presumably they're living there. And so, can you tell me, because you have those records in front of you, since you were a party, the kind of service that when you served the papers on them, was it personal service? You told me it was from the district clerk.
Correct. Because we filed an action under Rule 736 of the Texas Rules of Civil Procedure. It's an expedited procedure that allows us to get an order allowing foreclosure. And under those rules, service is completed when the clerk actually mails out a copy of the petition to the parties at their last known address.
If it was, you need to educate me. Somebody's going to lose in an NREM proceeding their house, maybe. Okay, so typically we seek to have personal service on someone. If the district clerk is now doing certified service, I think I usually give them permission, or it's under Rule 106 type of service. But if the expedited statute is different, let me know.
Yes, Your Honor, it is. It's Rule 736 of the Texas Rules of Civil Procedure. It has different rules for service. Let me pull it up here so I can get you the
Okay.
right.
While you're pulling it up, let me just take a 3-minute recess. Let me ask Ms. De La Casa. I can't hear you. It's okay. Turn on your microphone. Or is it me? No, I don't know.
Sorry, Your Honor. I had
No, it's okay. Which
things
case do
open.
you have? Which case do you have?
Yes, Your Honor, we're here for Jose Luis Gonzalez versus Gerardo de la Cruz.
Okay, and it's a motion for summary judgment.
That's correct, Your Honor.
And all right, so I will get to you. And then, Mr. Mann, what are you here on?
Yes, Your Honor. We're here on the Gorola case. We also have a motion for summary judgment on limitations this morning.
Okay. Gurola?
Yes, Your Honor.
Alfredo Gurola. Okay. And then I think those are the only other. Mr. Martinez, what are you here on?
Yes, sir, Judge. I'm here for the same case Ms. De La Casa is here for.
Okay,
Fred Hutter's wife just had a baby, so I'm substituting in for him for the day. If
okay,
I can
so,
entice the court, I anticipate it will be a very short hearing.
no, I know, but I'm still gonna finish this other matter. I just wanted to see if I need to talk less. So Mr. Martinez, this is gonna be a contested motion for summary judgment?
Yes, sir.
Okay, so let me get with you all, and then, Mr. Mann, I'll also get with you on your legal, well, it involves, legal fact probably, okay?
Yes, Your
Your
Honor.
Honor, I'm here also on hearing Hector Phillips. I'm here on Capital Funding versus Solis, entry of default judgment.
Okay. Let me ask you on the default, it's because the person didn't file an answer?
That's correct, Your Honor.
All right. And do you have your default paperwork or your proposed judgment?
I filed the motion for entry of default judgment that has the certificate of last known address, non-monetary affidavit, and then it's got the affidavit from my client stating how much is owed and attaching a statement.
No, I got that. I mean, I'm familiar that so you're already ready with that. And sometimes these are
All right.
routine matters. Let me just ask you real quick, what's the amount in controversy?
The amount in controversy is $14,478.73. Plus,
And
we're
the
also
nature of the debt incurred how?
it's they bought a mobile home. My client financed the purchase of a mobile home, so we're asking for foreclosure on it also.
Oh, all right. Well, since you're asking for foreclosure, let me get to you then, okay? But let me finish this first one first. Let me go get my code, and all of you are safe to take a break if you'd like for at least 10 minutes while I continue with Mr. Conway here. So if you go blank or whatever, that's fine. If you want to sit there, that's fine. Or if you want to just go blank while you go get a cup of coffee. I think I'm going to spend some minutes with Mr. Conway. Mr. Conway, you have your rule book, right?
Yes, Your Honor. I have the rules in
Okay,
front
let
of
me
me.
go get mine. I'll be right back. I'm just a few yards away from you.
Judge, I can't hear you. I think you're still muted.
Okay, thank you. So,
Sure.
so on one of these service is has a different meaning under one of these procedures?
Yes, the service is done differently under Rule 736. It's which they had to make everything a little bit weird in this rule. It's under 736.3, and it essentially says that service is deemed to have been completed when the clerk actually deposits the certified mail with the U.S. Postal Service. And then after that, they
Okay,
have.
yes. Let me read it real quick, okay? Thank you.
Okay, sure.
Okay. So you've got most of the compliance is stated by the district clerk, and then I don't even hear this matter unless there's been an answer filed.
Correct.
So go ahead and send the order. You're not asking for anything other than the expedited foreclosure.
Correct, Your Honor. We're just asking for an order allowing us to foreclose on a home equity loan.
Okay. You're not getting any fees from this procedure. You're going to conduct another procedure for the sale of the property and.
Right, yes. Then
Okay.
it essentially allows us to do non-judicial foreclosure processing.
No, yeah. Yeah, I know it's hinky because it was so difficult. So to find parties and to make sure, and then, sometimes you had multiple parties.
Right.
All right, so go ahead and send it to Robert, and I'll sign. They didn't have notice of this hearing, though, and you weren't required to give them.
We mailed out a notice to them of the hearing.
Okay.
It went to the same address as the service, but yeah, we mailed the notice out, yes.
All right, so go ahead and send it to my court coordinator, and then it should be signed in the next week. If it isn't, don't be shy about following up to find out why you didn't get it signed.
All right, I will do that, Your Honor.
Thank you very much. All
Thank
right.
you.
Everybody else, thank you for your patience. Let me see. Okay, Ms. De La Casa and Mr. Martinez. This is a motion for summary judgment.
Yes,
The
Your Honor.
movement, the movement is
I am Judge.
yes, Mr. Martinez. So
Yes, sir.
tell me the nature of your summary judgment.
Judge, it's a tractor trailer case. We're pleading the workers' comp bar. The plaintiff was a co-employee. He was asleep in the sleeper berth at the time of the accident. They were both operating under the carrier's authorities, so they're both statutory employees. It's that simple.
Okay. And then the basis of the summary judgment.
Judge, that is the basis of a summary judgment. The workers' comp bar, they were both covered by workers' compensation. That is an exclusive remedy. Judge, you've heard this motion before. I think Mr. Hutterer has been before you at least twice to discuss it. There's the motion, there's a response, there's a reply.
Okay, Mr. Martinez, thank you. Thank you for reminding me. Ms. De La Casa, were you there at the other 2 times?
I was not at the other hearings, Your Honor, but I have read all the briefing, and I think both sides have briefed it extensively. And I think over the time that it's been pending, the only thing that we have learned is that my client is not an employee of Impetus. And Impetus was the company that had the workers' comp coverage. And this came out and is cited in our latest response from the employer. The owner of the company said that is correct. My client did not work for the company that actually had the workers' comp coverage. And if you recall, Your Honor, they also argued all of the inequities and 2 theories of liability, equitable estoppel and fraud, because my client was never told about the workers' comp, assuming he even qualified as an employee, because the owner has said he is not an employee. They took him to Mexico, dropped him off, or right at the border. They told him they would not pay for medical expenses. There's no notification at the workplace saying there was workers' comp. In fact, the company itself didn't notify the workers' comp carrier until 2 years after the accident. And so we have pled various theories as to why the summary judgment should be denied. And I think last year we also added fraud to our pleading. And so I think, this has been argued extensively by everybody.
It has. I do recall it now, and I think I have something floating around here with that, where I had looked at that. So if I do deny the motion for summary judgment, then where are we at as far as trying the case? If I do, Mr. Martinez, I'm not saying I'm going to. I'm just going to take a final look at the paperwork.
Judge, honestly, I'm not sure. I'm not even sure there's a trial date at the moment. I don't know if there is.
Okay.
Judge, and I'm happy if it helps. I'm happy to send you. Ms. De La Casa is correct. There's
no. I recall, Mr. Martinez. I recall now. I'm telling you that I've heard that. I remember I remember the facts about the sending them to the hospital, dropping them off at the border, and which I thought was pretty well. It's not odd. It just is not conventional if there's workers' comp coverage or whatever.
Right. Yeah, it is. Judge, I'm with you. It's certainly unusual. Judge, the only thing I would say is 2 things. If you want additional copies of paper, let me know. I'm happy to send the entire. I'll send you the whole thing in a binder if it's easier for you.
Is it how thick is the whole binder? How thick is it?
Judge, it's not bad. I mean, look, this is everything.
Oh, okay. Well, I'm saying if it's already electronic, you can send those to Robert by attachment, and of course, a copy to Ms. De La Casa.
I'm happy.
But otherwise, I'm going to be hunting it down. But that would help if you just send it out, and I can get it printed out and make a definitive decision. I don't recall if I said I'm going to give you a decision or not. But since we're here at this stage, if I don't grant the motion, there has been no progress on the rest of the civil case, and it's not the oldest I've seen, but it is 2022. So this hasn't even gone to mediation. I take it.
Judge, I think that's true. I think all parties were sort of waiting for the ruling on the MSJ to figure out what direction the case is going to go in.
Okay, and then the other thing is different parties operate differently on how they do their discovery and stuff. But I take it with this amount of time and with the allegations that have been made and all, there has been some discovery conducted?
That's correct, Your Honor.
Yes,
There have been depositions taken of the owner and the two
Okay.
individuals. And
Okay,
without going into the details, I have had some very good conversations with the representative for the
no, I get it. I got that. And I don't want to get involved that would be any kind of reason that I make my decision. But if I grant the motion for summary judgment, we're in a different ballgame, right? But if I deny it, well, it's going to take its own course. But if I deny the motion for summary judgment, I do want to take this opportunity so y'all don't have to come back to ask you to mediate it in the next by the end of the year, or if you want less time, I'll do it even faster.
let's
Judge,
do it even faster.
Faster? Okay. So let's do it in the next 60 days. But from the date that I give you my order, well, each of you have submitted orders granting and denying. Is that correct?
yes.
I will verify and I will make sure that we have one on file and we send it to Robert as well.
Yeah, you don't need to file the order because the clerk isn't going to take it. They only take stuff like that if I sign it. So just send it to Robert, and then well, Robert can hear me right now, but I'm going to get on this as soon as I'm through with this hearing. And then
May I ask for, instead of 60 days, could you extend that to 90? I won't be
I
involved
will.
in this case.
I will. Okay,
Thank
I
you.
will.
Mr. Hutter, his wife just had a baby, and my understanding is he's trying very hard to take several weeks off.
No, I got it. Yes, I will. I mean, it's so that almost takes us to the end of the year, Ms. De La Casa, but that's fine. And if it doesn't get settled on the mediation, then Robert will give you jury trial dates right now.
Okay.
That way you'll have those already pending when you go for the mediation.
Very good.
And then the last thing, this may apply to you. I guess you heard me say I'm going to be retiring in a year. 15
Yes, sir.
months. So if you wanted me to try a case, please take me up on that and repeat the magic words to Robert. The judge said he would try our case before he leaves. Otherwise, I don't even know who's running for my bench, so I don't know who you're going to get.
Fair enough.
Okay?
Yes, sir.
All right. So let me get. You will have an answer, and then send the orders in, and you may get it just by the order that I sign. I remember that. And also, Mr. Martinez, just to let you know, we didn't have an in-person hearing, did we?
Judge, I don't know if the prior hearings were in person. I didn't
Yeah.
see a record of that.
All I can tell you is my recollection at the time of the arguments and the circumstances was that it didn't sound like a workers' comp case to me. But I'm going to read everything and make sure that that's where I was headed and issue my order. And I won't hesitate to issue contrary to that if your pleadings support that. A lot of times also, mainly because of the jury issues that are there, that sometimes, actually most of the time in my mind, it's like, oh no, this one's going to have to get tried because there are fact issues involved, substantial ones. So anyways, those are my thoughts.
Understood.
I will get on that, and thank you very much, Mr. Martinez. Good to see you.
Yes, sir.
Very often, even in person.
They still let me in the courthouse from time to time, Judge.
I know. I bet they do special security with you. I'm kidding. Y'all take care.
Thank you, Judge.
And you're excused, yeah. All right. Who's Nicholas del Campo? Who are you here for, sir?
Hi, Judge. I'm here for the Gurola matter.
Gurola.
On
And
behalf
you're
of
here
David
for that,
Chavez.
Mr. Mann, also?
Yes, Your Honor. I'm to
Okay.
move it.
Yeah. So give me a little briefing on your legal issue.
Real quick, Your Honor, and follow up to what you just said. This case is perfect for summary judgment because there are no fact issues as it regards the timing of filing and service of the lawsuit. So it's teed up perfectly. This is a medical malpractice case. I represent a local surgeon named Dr. Cox. he provided some care to the decedent back in July of 2019. And because this is what the legislature calls a healthcare liability claim, basically a med-mal claim, as the court knows, a claimant has 2 years to file suit from the date of the alleged negligence. So, cutting to the chase, Your Honor, the plaintiff filed the lawsuit in a timely manner. All right. But as the court also knows, under Texas law, there are 2 steps to filing a timely lawsuit. You have to file it
They have to
timely.
find an expert.
Well, that too. That too, but they, on the limitations issue, they have to show due diligence in service of the lawsuit. That's the second part of this, and that's why we're here. As the court is, I just told you, the plaintiff filed it in a timely manner. But here's why we're here. They didn't get, although they filed it in, let's see, July, it was July 30th of 2021. Dr. Cox was not served until April 3rd of 2023. Here's the issue under Texas law, and the court probably has dealt with this before. On the due diligence issue, what the court should look at is, did they exercise due diligence? In other words, there can't be extended periods of time when the claimant was doing nothing in order to try to get the lawsuit served. And where there is no factual dispute whatsoever, Your Honor, is this. The plaintiff has filed a response, and it contains an affidavit of their process server who says that, I believe it's a she, went out there multiple times in 21 and 2022. The problem is for the plaintiff, quite frankly, and the reason why we're entitled to summary judgment is that there is no dispute that between April 22nd, 2022, and when the citation for the first amended petition was sought, which was March 22nd of 2023, that's a period of 11 months. The plaintiff has come forward with no evidence whatsoever of any action that occurred in that 11 months to try to get my client served. He was not served, as I told the court earlier, until April 3rd of 2023, which is over 11 months since citation was sought on March 22nd, 2023. Your Honor, I cited a bunch of cases. This is the El Paso court's taken this, the Texas Supreme Court. I lost count of the number of the 14 appellate courts that have looked at this issue. 4 months, 5 months, 8 months, 9 months have all been found as a matter of law not to constitute due diligence. Here we're talking about, I'm sorry?
What does our court say?
The Eighth Court of Appeals, I cited the court to a case called Montes versus Villarreal. It's a 2008 case holding that 4-month delay did not excuse the duty to exercise due diligence. And that's on page 3 of my reply. I think we cited it in the motion as well. In other words, you have to come forward as the plaintiff or the claimant with evidence explaining delays in service. And we've got this 11-month period where there's absolutely no evidence before the court, as was plaintiff's burden to come forward with, to show what they were doing to try to get service on Dr. Cox. Your Honor, there is no factual dispute here. There's no fact to hear. All the dates are stipulated to between the parties.
If I may, you're more familiar with the history of this case.
Yes.
Okay, and what's been done. The hearing is their opportunity to come forth to explain that. Or are you saying that they're past that opportunity as well?
No, I think they can explain and argue today all day long, Your Honor, for sure. But what I'm saying is the Texas law clearly requires evidence of something that they did in this 11-month period of time to try to affect service on the defendant. And they've done that. They filed a response, Your Honor, and we've supplied it to the court. And they did what I would do. I've had this issue, and they filed an affidavit of the process server that outlined what the process server tried to do. That's all fine and good, and we don't dispute the affidavit. The problem is the last time that process server tried to serve my client was April 22nd of 2022, and they didn't seek citation of the amended petition for another 11 months. And there's this 11-month period of time where there's no evidence that they've come forward with to tell the court, what were you doing in that 11 months to try to get Dr. Cox served? Your Honor, this is
an
like,
amended citation then.
It was.
Okay.
It was.
Were any of your cases, or particularly the eighth one, did it involve abuse of discretion?
I don't recall that being in any of those cases, Your Honor. They mostly relied on the court looking at the facts of the case, the time period of the delay, and what evidence was before that court.
So they were
to
on
explain
appeal.
The delay.
They were on appeal after
Correct.
a trial.
They were on appeal after either a trial or a judgment or a summary judgment.
Okay.
That's correct, Your Honor.
Your Honor, may I respond briefly?
You may, sir. Go ahead. And you know what? I mean, I can put whatever you want on the record, but I'd like to hear this stuff, and I don't mind.
So, Your Honor,
go ahead.
Mr. Mann is correct. We did try to serve Mr. Cox. However, at that time, Mr. Cox got suspended due to this case by the medical board and had to close his practice. There was a period that we could not locate Mr. Cox or where he was. As a result, that is the delay. We weren't able to locate him. And then there was a switch of attorneys. Mr. Chavez took the case, reissued the citation, and was able to locate Mr. Cox. Now, we did try to do our due diligence. At the same time, COVID was happening. There was a lot of things going on. So therefore, you know, we did try to do our due diligence and try to serve Mr. Cox. We tried to serve them 4 different times prior to reissuing the citation until we finally were able to serve him when Mr. Manny stayed in April 3rd, 2023. In the meantime, I believe Mr. Chavez also attempted to conduct discovery with Mr. Mann to determine where Mr. Cox was, Dr. Cox was, but he wanted to resolve other issues first. However, I'm not too sure about that, so Mr. Mann, correct me if I'm wrong on that fact.
Let me just stop you there so I don't forget, and you got your stuff written down so you won't forget. You attempted discovery. When you say that, was it beyond the oral discovery to find out where he was, or is there anything?
I wouldn't be able to tell you, Judge, because that was communications with David Chavez, the other attorney. So I don't know the content. I know that he mentioned that to me prior to this hearing, but that's what I know regarding Dr. Cox. However, we do feel that we did attempt due diligence. And like you said, it was an amended citation after we couldn't find him for several months.
Okay, so your filings, you want to stand on them and whatever you have on there for the testimony that you may need on this, or do you want a live hearing?
I think, Mr. Mann, I'm okay with just what we have.
With what you there, I take it there's affidavit.
Yeah, correct.
Okay. All right. I guess the next question is also, has this case gone to mediation yet, or is it set for a trial?
No, neither, Your Honor.
Neither.
I believe a mediation may help resolve some issues.
Yeah. So that you don't have to bounce back and forth. And the way that my court is operating, you can get a trial date setting next year, which at least will give you some date to shoot for, and will get something for me to shoot for. It won't affect my consideration, Mr. Mann, of your motion. And we can get those moving. And then what I did with the other party, if I deny the motion for summary judgment. I would like it to go to mediation. I can't recall now who are considered good mediators on these med mal cases. Anybody
I
in
believe
particular?
Judge Ancliff would be good.
Okay.
Yeah, Judge Ancliff is good. Carlos Cardenas has started
Good.
doing these. He's
Okay, I don't
real
mind. You know,
knowledgeable.
I know Carlos, and that he started, and actually he's been at it for a little bit, and he probably has more flexibility as far as on the schedule. I don't mind asking you to please go to him to mediate it, Mr. Del Campo. Do you have a problem?
Not an issue, Your Honor.
So don't even contact him yet. Let me go through on these hearings, and then everybody's resting on their pleadings plus whatever you told me right now, and let me go from there. I will tell you, Mr. Mann, that the well, I'm going to see what it says, but this doesn't appear to be a case where Dr. Cox was there all the time and somebody could go knock on his door and find him anytime.
That
During that
may
period
be
of time, from what Mr. Del Campo said.
that may be true, Your Honor. But what only thing I wanted to add to that is I've had plenty of plaintiffs' cases in my almost 30 years, even though I mostly do defense, but I do plaintiff as well. What we all do, and the court's dealt with this, is we file a motion for substituted service, right? And this would add to the due diligence argument, and I believe it's in our pleadings. You file a motion for substituted service, and that was never done.
Well,
So-
there's no requirement that be done. I mean, I'm saying that if you, but I get it. It goes to the
Yeah.
diligence. I go
But
to
it's
the,
not a mandatory requirement.
the other little curve there was that it was COVID. How far into COVID were we then?
Mid-COVID, Your Honor, 2021.
I mean, things were way different when there was COVID. Okay, let me look at that, and then let me give you a ruling. For yours, I'm going to be out of town next week, but I want to take that your pleadings and stuff and look at them. So give me that week to take a look at it, and then I will be giving you a ruling. And then if it happens that that I deny it, you can even get the trial dates right now from Robert, because you having a trial date and then I grant a motion for summary judgment, there goes your trial date. So you can get those dates from Robert right now to put you on a trial track. But if I deny it, I am asking you to, within 60 days of the denial, to go to Mr. Cardenas for the mediation.
Thank you, Judge.
Yes, Your Honor.
So bear with me for a week, or I think I counted 10 days. I have to go out of town. Anyways,
Do you want us to submit competing orders, Judge, or will you do your own?
no, submit the competing orders, because if I have them, I can just sign them instead of like, oh, let me go. And then, there's no, well, I guess if I don't make any special findings, and these are routine matters, nothing happens, but I guess the Court of Appeals will take into account whatever it is that I had before me.
Correct.
So I think it's a pretty simple order that I need to enter.
Yes, Your Honor.
Yes, Your Honor.
Okay, I'm just curious. The nature of the medical malpractice was what? The alleged.
My understanding is the main issue is that they're alleging that Dr. Cox didn't come in to see the patient in a timely manner.
Oh, okay. Jury issue, Mr. Mann?
That
Jury.
is, that definitely is. The limitations facts aren't.
All right. Well, thank you very much, and I'll get back with you on that, or you'll hear from Robert.
Okay, thank you,
Thank
Judge.
you, Your Honor.
You may hear just because the order got filed.
Yes, Your
So we
Honor.
don't have to burden
Thank
your
you, Judge.
secretary with the notice. Okay, thank you.
Thank
May we
you.
dismiss?
Yes, sir, you are dismissed. Thank you very much for your courtesies.
Thank you,
Thank you,
Judge.
Judge.
Okay, Mr. Phillips.
Yes, Your Honor. I'm still here.
Yes, me too. Let me find out where I wrote your name. Which case, give me your case again.
2025 DCV
No, I
0164
know the name.
Capital Funding versus Brenda Solis.
Oh, okay. Okay, the mobile,
Yes, Your Honor.
$14,000 owed, breach of contract. So you filed the lawsuit and an answer wasn't filed?
That's correct, Your Honor.
Okay. And then also, tell me about the service.
Well, we
Personal
served
service?
her, she was served personally,
Okay.
and the return has been on file. She was served in January, I think January 27th of this year.
Okay, she's had plenty of opportunity to operate off that.
Yes, Your Honor.
Are you asking for attorney's fees?
I am asking for attorney's fees, Your Honor. I submitted a default judgment and I'm asking for attorney's fees of $2,000.
Okay, that's reasonable. You know, I'm from the old, in the old days, they just are, well, it's not, Mr. Phillips, one time a collections, obviously a collections lawyer, very experienced, sent me a whole brief on the argument supporting the contingent fee and, the economics of it and all. So I've read through that, but I do think 2,000, even for that amount involving a lawsuit is not unreasonable. If you wanted 5,000 or 10,000, then it'd be like,
No, what I'm, and one of the hardest thing, I tell people, one of the hardest thing that I do as an attorney is the billing. How
Yeah.
much to a bill? I mean, some things that there's very, 2 or 3 attorneys in El Paso do that, I can do in a couple of hours. How much to charge for that? When
Yeah.
it's my experience that's valuable to the client.
no, yes.
Yeah.
All right. Well, submit the default to Robert, and if there's any issues on that, we'll get back with you. Otherwise, give me until next week, and don't be shy about following up to see why you didn't get it. The only reason I'm saying that, I don't have it in front of me. You're proposed.
Okay, I think we already submitted it, Your Honor. I think your officer. If not, I'll make sure you get it.
If you submit it electronically and it's readily available, just email it to Robert. A lot of
Will do,
lawyers
Your
don't know that the clerk, I've had lawyers from out of town send it to the clerk, and the clerk isn't going to do anything. They're not even going to accept it because there's no judge's signature on there. So just send it to Robert. And then if you can, you don't have to have it prepared all over again, right?
Right.
Yeah.
Well, we'll do it. Make sure you'll get it.
Thank you, sir. And you're
Thank you.
excused, and take care now. Are you not here? Are you in El Paso?
No, Your Honor, I am currently in Mérida, Mexico.
I was going to say, you got palm trees outside your window, and I'm saying,
Look at that, Your Honor.
we're in a desert here. Well, good for you.
Yeah.
Good for you.
I'm living here.
Well, that's curious. I mean, I'm 69, and I actually have, as a child, I lived in Mexico, but my wife, who's a Mexican citizen by virtue of her dad, she's like, nah, I don't think I want to go live down there. And you can really have a nice life down there.
It is absolutely gorgeous over here, Your Honor. I mean, right here in the trees that are right here. In the mornings, one day I saw a bird with the red head. I think it was a woodpecker. I don't know. I don't know enough about birds.
Yeah.
A couple of days ago, I saw one with a blackbird with beautiful blue wings.
Yeah.
Yesterday, I saw one with the yellow tummy and a white and black head. I mean, there's a lot right there while I'm working.
And it's so easy to get to back to the States now from these cities.
Right. So
I'm
loving it over here. I've been here close to 3 weeks. Tomorrow will be 3 weeks.
So what's the longest period of time, more or less, or what's your average period of time for going down there?
Well, I just, like I said, I just moved down here in last week or 3 weeks ago. I got to go back there because I have couple of hearings and I have a couple of closings, a foreclosure I have to handle in a couple of weeks. So next week I'll be in El Paso, but I'll be there and then I'll come back here for another 3 or 4 weeks and then I'll go back there for a week. So about 3 weeks out and 1 week back in.
So when you fly from, I take it Juarez, how many flights there's no
Well,
direct flights to Merida.
Yeah, there's no direct flights from Juarez. There's no direct flight from anywhere. I can go through Dallas on American Airlines and direct flight from Dallas or through Houston direct. If I go to Juarez, I can go to Guadalajara, Monterrey, or Mexico City. When I came down here, I brought my dog since we were coming down here full time, and I didn't want him to go on 2 flights, so I flew directly to Cancun,
Mhm.
rented a car, and then drove over here. It's about a 3 hour drive, 3.5 hour drive from Cancun.
Yeah. Well,
So,
congratulations. I mean,
thank
it's
you, Judge.
something that I'd like to think about. Well, I have thought about it, but you know, I'm not retired yet, and I don't plan to be. But I think it's in my cards. I certainly
Yeah,
have the ability to
yeah.
get around.
I had to start
Yeah.
thinking about cutting back on it because I had a heart attack, and then on top of that, I had another stent put in, and so I need to slow down, and so
Yeah.
I'm not working the whole day. I'm working, maybe half days,
Yeah.
which is perfect for me.
And nowadays, you're connected to the whole
Right,
world.
right,
I mean,
right.
you can still, everything's electronic now.
Right. I'm meeting clients. They go to the office and I meet them through Zoom. Of course, the hearings
Yeah.
are Zoom. So yeah,
Well, good for you.
thanks, Judge.
I envy you, and I
Thank
wish
you,
you well.
Judge.
Okay,
Thanks.
so send that over to Robert, and then let me get it signed.
Will do.
All
Thank
right.
you, Judge. May I be excused?
You may. Thank you.
Thanks. Bye-bye.
All right, Erica. Thank you.
Now you have the in-person hearings, Judge.
I have in-person hearings.
That's correct.
Okay, I'm going to the courtroom. Thank you.